praying for the following orders. 1. An order restraining the committee set up by the President to inquire into the 3 petitions against the plaintiff, composed on 2nd, 3rd, 4th, 5th, and 6th defendants, from proceeding with an inquiry, the execution of the terms of reference of the committee, or taking any action in connection with the purported determination of a prima facie case made against the plaintiff until the hearing and final determination of the instant action. The second one, an order restraining the 2nd and 3rd. So that is Justice Gabriel Scott Palmer and then Justice Samuel Kwame Adibwesiedu.
Okay, those are the 2 Supreme Court judges that are on the committee. Okay. One is a chair, the other is a member.
Yes.
Okay.
An order on the 2 from presiding over or participating in proceedings of the committee appointed by the President to inquire into 3 petitions purportedly presented for the removal of the plaintiff as Chief Justice of the Republic until the hearing and final determination of the instant action.
Okay. Yeah. Okay. That's 2. I think she's taking some more on the second page.
Okay.
Yeah.
Okay. So, an order suspending the operation of the warrant for suspension of the Chief Justice, purportedly issued by the President under Article 14610 of the Constitution, until the hearing and final determination of the instant action.
Okay.
And the 5th one says any further orders as to His Honorable Court may seem meet. And so those are the orders.
Those are the what the reliefs she's seeking.
Yes.
Okay. Under the interlocutory injunction. So a few things, and the interesting part is that the 2 people who she's targeting are her colleagues on the bench. That's worrying because I think that she may know these colleagues quite well. So one of them was there before she came. I think the other one came after her or something. So Justice Gabriel Scott Poamang was nominated, vetted and approved by Parliament to the Supreme Court during the Mahama tenure, first Mahama number 1. And of course, Justice Kwame Adibwesiedu, that nomination was done by Akufo-Addo, vetted and approved by Parliament. So 2 different people, one of them nominated by the same person as her, during the same tenure as her, and then one person by Mahama number 1. Justice Gertrude Torkoo says both of them, the 2 of them, should not continue to be part of any committee that looks into the petition. Secondly, they should stop the process, the whole entire. Remember, the committee started its works, I think, somewhere last week. So they said she's saying stop the committee from doing any further work until you have heard me and determine my case. Secondly, restrain those 2, even if the committee has to go forward. Those 2 should not be part of the committee, and they should not have anything to do with the committee. I'm saying the 2 Supreme Court judges on the committee. The 3rd one, I surmise from what you are saying, I get the impression that she's saying the warrant that was issued suspending me
should be reversed.
Okay, injunct it for now. So which means I return to work.
Yeah.
Before you hear the matter. So very interesting request being made by the Chief Justice. Now, we'll get some expert opinion on this, but I think I have been looking for the suit itself. I'll find it and I'll share with you exactly what's contained in that suit. Anyway, but in the meantime, it seems one person has read it. Professor Kwekwaza has been sharing some thoughts on exactly what the Chief Justice is looking for. I want to find out whether the facts she's relying on are the same facts that Adenta Kumi took to in a petition.
Yeah.
He's relying on
same.
this.
Yeah.
Oh. This madam. Anyway,
Yeah.
it's a matter in court.
Very similar.
Yeah. So exactly what is justice, Doctor Professor Kwazan saying?
Okay, so this is what he wrote.
Yeah.
Gogo has obtained and reviewed the latest writ filed by the suspended Chief Justice Gertrude Arabasaki Tokono. The writ lists 16 reliefs and orders, some bold, some novel, some familiar, and seeks, in essence, to halt the work of the committee set up under Article 146 to investigate her conduct. Then he says, we do not judge, but we do observe. Okay. And here is what we see. Reliefs 1 to 3, public hearing, please. The Chief Justice wants a declaration that she's entitled to a public hearing and can waive in-camera proceedings. Gogo raises an eyebrow, but Article 1468 says such proceedings shall be held in camera.
Yeah.
It's not optional. It's not a privilege. It is a command. Reliefs 4 to 6. Prima facie, sir. She says the prima facie dissemination was flawed, lacked reasoning, and violated her right. Okay. Gogo humbly notes that the stage is not a judgment. It's a threshold filter. Not every constitutional process mimics a full trial.
Okay.
Now, relief 7 to 9. Suspend the suspension. She wants her suspension reversed, arguing that it is unconstitutional and an assault on judicial independence. Okay. Gogo sees it differently. Article 14610 makes the suspension an option once a prima facie case is found. The president is entirely within his powers to suspend her, as he did with the former Shraj Commissioner, Ms. Lamte. Now, relief 10 to 13, disqualify the judges. She wants Justice Pauman and Edibu Esiedu off the committee, citing bias. One ruled in favor of a petitioner in the past, another sat on a related injunction panel. Gogo gently points out, Ghanaian judges are often on multiple cases involving similar names. That's not bias. That's the job. In fact, the CJ herself has been very harsh on lawyers who tried to raise potential bias by Justice Gaiwu, admonishing them, quote, not to go there, end quote. Really 14, disqualify the lay members too. Now she wants to disqualify the non-judicial members as well. On what basis? Gogo looks closely and finds little. No conflict, no misconduct, just more procedural fog. Really 15, stop the committee altogether. This is the heart of the matter. She wants the committee stopped cold. Gogo has seen this request twice before, both times dismissed by the Supreme Court. Third time lucky? That's a question. Now relief 16, and anything else the court may deem fit. Yes, the always convenient catch-all prayer, open-ended, undefined, unmoved. Gogo's bottom line. So that is what the observation he has made finally. We do not judge, we just observe. 3 writs, 2 injunctions, 16 reliefs, timing that always coincides with scheduled committee sittings. A familiar pattern? There's a question. The Constitution must not be turned into a maze for evasion. The court must protect its time. The process must be allowed to work. If this continues unchecked, Gogo fears Article 146 could go from a tool of oversight to a treadmill of obstruction, moving all the time, but going nowhere. Let the institutions work. Let the evidence speak. Let Ghana move forward. The law is the law.
Thank you. Let's speak to lawyer David Ametefe. Thank you very much for your time. Good morning to you. I hope you're well.
I'm quite well, just tired.
Have you seen the suit in question?
To be honest with you, I'm far away from Accra. I have no access to Radio Go. I've been out since the beginning of the week, and I'm just seeing pockets of noises here and there. I started combing through the social media, and I see the new rate that was issued, the Supreme Court, where the CJ or CJ now suspension, Madam Torkoo, now being the plaintiff against, I think, 5 defendants. That,
And what do you make of what she has filed?
is so convoluted and quite confusing. I believe a lot of people might be asking questions. What exactly is the pivot of the argument that the plaintiff, through her lawyer, seeks to canvass before the apex court? My understanding, I think I saw about close to 15 or a minimum of 13 reliefs being sought. Essentially, I think the plaintiff is trying to affect certain rights which she thinks the court must enforce. The right to fair hearing and all that. However, what appears to be quite confusing to me is the fact that these rights have been laced constitutional interpretation. Otherwise, the proper forum would have been the High Court under Article 33 with respect to enforcement of fundamental human rights. But in order to take the matter out of the purview of the High Court, these rights have been laced with what the plaintiff claims to be a matter of or a matter requiring constitutional interpretation and thereby invoke the original jurisdiction of the Supreme Court.
And I think this time around, one of the things she's requesting for is that the in-camera hearing aspect be dispensed with. She prefers to a hearing in the open. Is that a request that's standard? I know there's a matter before a court, but from your reading of the Constitution, how does it sound to you?
Then you have to forgive me because this matter is a fresh matter that has been filed and therefore is pending before the Supreme Court. I'm mindful as a practitioner and a lawyer for that matter that I should not be seen to be commenting so much merits of the case. However, I also saw some audio and recording and statements made by lawyer for the CJ, Mr. Godfrey Dami, who is the immediate past Attorney General, commenting even on the merits. And so in that regard, I should be forgiven if I'm seen to be straying somehow into that domain, but I'm cautious not to go too far. Yes, the in-camera hearing is mandatorily provided by the Constitution. I think Article 146.8 makes it mandatory. It is couched in a mandatory term that such hearing shall be in camera. And so I don't see why one facing such an inquiry could decide that the hearing should be made public. The Constitution does not admit of any such option. And had the president rather gone ahead to make this hearing public, I think the former Attorney General, the lawyer, Ametefe Disects, would have been the first to accuse the president of violation of the Constitution. Now that the president is keeping strictly with the dictates of the Constitution, Ametefe Disects, who is also I would say a Chief Justice on suspension, who is required to know the law or is deemed to know the law, will be asking that the Constitution should be violated by the president. I find that quite tenable, and we'll see how the Supreme Court, if this matter comes to be heard on the merits, how it will be determined that the Constitution should be violated. Implicit that is what I would say. A number of the rules, they congregate around this same position taken by the plaintiff, that the in-camera hearing as provided by Article 146.8 should be violated. That's what it means. The other leg I see is that it seems to me that the plaintiff is asking that the prima facie determination by the president was unconstitutional and should be set aside. Am I right?
Yes.
You have a read before you, so.
Yes.
So
she said it was flawed.
Flawed in what sense? They are stating that the president ought to have given the reason or the reason behind the finding or how he arrived at the finding of a prima facie case, thereby necessitating the next step, that is the constitution of the panel for the hearing. Is there any precedent that we can point to where that prima facie determination by the president was communicated in a reasoned judgment or in the nature of a decision as a court would do? Nowhere in the Constitution, under Article 146, that in the determination of a prima facie case, either by the president or any other body authorized to do so, required to give a reason or communicate that in the nature of a decision. Here again, the plaintiff is urging on the Supreme Court to look for what I'll call a needle in a haystack. It is a clear case of what I'll call a fishing expedition, to say the least. The other aspect which the plaintiff is urging on the court is that the suspension should be declared as unconstitutional and therefore legal. Is that the case?
Yes.
The question to ask is whether Article 146 provides for or empowers the president to suspend a chief justice or a member of the Superior Court or a justice of the Superior Court against whom a petition for his or her removal is pending? The answer is yes. Article 146.10 gives that prerogative to the president to suspend pending the dissemination. And I believe that provision, Article 146.10, is just a codification of the common law or the normal employment law. In any employment setting, such as even Radio Gold, then you agree with me that where your employer thinks that you are facing a disciplinary action or hearing, and the position you hold will be prejudicial to the outcome or the process, or keeping you in that office will interfere with the process, you are normally asked to, you are suspended or interdicted. And this is just what has been codified into the constitutional provision. The president may or may not. It is the president's own prerogative. The president chose to exercise that power conferred on him by the Constitution. And they are saying that exercise of the constitutional mandate is unconstitutional. The other aspect, I think a number of reliefs appear to be suggesting that the 5-member panel should be qualified. In other words, the entire panel or committee be dissolved.
Yeah, all members of the committee.
Yes, because if you categorize them, the first attack has to do with the 2 members, that's the chairman, and the other justice of the Supreme Court. The other 3 are not judges. Okay. So the first attack on the judges, my understanding is that the plaintiff is saying that in the case of Justice Warman, who is the chairman, he has sat on some aspect of the case previously coming before the same court. And the same applies to Justice Silvi. I don't know whether it's in respect of the Atifwa case.
In fact, in the case of Justice Poorman, this is what they say, that he is not qualified to be a chairman of or member of the committee set up by the president to inquire into the petitions against the plaintiff on account of having adjudicated and given various rulings in favor of one of the petitioners, Daniel Ofori, in actions filed in the Supreme Court.
So it is not necessarily because he has adjudicated on a matter having to do with this CJ petition.
No.
Some cases.
Yes.
Oh.
That has to do with one of the petitioners called Daniel Ofori. So I am guessing he sat on a panel.
So anything having to do with Daniel Ofori, he must leave. Has this been the position taken by the CJ Torkoo herself? I have a number of cases where CJ Torkoo sat as a member of panel of the Court of Appeal, whilst she was Justice of the Court of Appeal. Other aspects of the same matter or matters came before the Supreme Court, where she was a member of the panel. She never recused herself. Has it been the practice that once an individual or a group of individuals as parties appear before a judge in one matter, unconnected to another matter in future, that judge must necessarily withdraw from partaking in a decision? I think not. In the case of Justice, I said I don't clearly understand
Okay,
what
his own is about. So let me just and he says he should be disqualified as a member of a committee set up by the president to inquire into the petitions against the plaintiff because at the time when he had already sat as a member of the Supreme Court constituted under Article 1282 of the Constitution to hear an application for interlocutory injunction filed by a Ghanaian citizen challenging the Article 146 proceedings initiated against the plaintiff violates the independence of the judiciary.
Oh, okay. In the case of Justice, I said the argument may even appear to be more flawed. First of all, my understanding is that the panel that was constituted initially to hear that interlocutory injunction application against the case of Honorable Ametefe had no sitting or hearing when the matter was adjourned.
Yes.
And when the matter came for hearing, Justice Esedu had already been named as a member of the petition panel, and therefore was no longer part of that panel. The panel was completely reconstituted. So, where exactly is the complaint here? The argument doesn't seem convincing, but we'll see how the Supreme Court will determine this.
Well, there are those who have raised issues with the fact that she is even taking this matter up in court in the way which she has done. They have spoken about the optics not being good, and there's also a former rector of the Ghana School of Law who even raises issues with the conduct. He has even gone as far as to call it unconstitutional because the things she was raising are issues that she should not bring before the court. But on the matter of the optics, do you see any problem here, or is she just exercising a right accorded under the Constitution?
Sarah, two very important and noble men in the law have spoken. Coincidentally, they are both Asaris and Torkoo. Professor Torkoo Asaris made a detailed analysis of this without being judgmental. And I've also shared Mr. Torkoo Asaris, formerly director of the Ghana School of Law, very well citizen lawyer. What do I have to add when these two great men speak about the law? Clearly, you cannot seek to subvert the Constitution by what appears to be a use of constitutional means. One too many. This has happened, and I think the Supreme Court must stand up to some of these things in order that this record will be pleasing to right thinking members of society. Honestly speaking, the decisions of our superior courts are not localized. They are international in nature. They are referred to by courts of other jurisdictions and even at international tribunals and courts. They form part of international law and can be relied on to make decisions where none exists elsewhere. And that is why any decision of our superior court, especially the Supreme Court of Ghana, must be one that is above board. Not too long ago, ECJ was part of a panel that rendered a decision my very humble, was an unconstitutional decision. This decision has to do with the Afenyomatin case with respect to the vacant seat and the speaker, what they call it, saga. Clear provisions of the Constitution that if you enter Parliament as an NDC MP and decide to leave your party and become independent while that term of Parliament is subsisting, your seat is automatically deemed to be vacated. The same way, if you enter the House as an independent MP and choose to join a political party whilst your 4-year term in the House subsists, your seat is deemed to be vacant and should be declared. This CJ, chairing a panel, thought otherwise, and in fact completely overturned the Constitution. That decision to date remains a problem, and we have to find a way of having it off our law records. It's the same thing that they are seeking to do. To have the president violate the Constitution under the guise of a constitutional interpretation.
And then finally, there are those who even raise an issue with the fact that she's being represented by our immediate past Attorney General. That outlook is partisan one. And secondly, his recent record should have even deterred the CJ from even, no matter how she feels about him, having him openly represent her. Do you agree?
Yeah. I don't know what informed the CJ's choice of lawyer. Not too long ago, Mr. Dami was lawyer for, or is still a lawyer for Honorable Asifua, which case is still pending. Mr. Dami, the immediate past Attorney General, and a politician for that matter, MPP, know that. I think that the CJ should have done herself a lot of good by engaging some neutral lawyer. Okay? The face of the Dami itself gives the matter a certain coloration. And I heard Mr. Dami in his media statement that it was about time that good men stood up for what he deemed to be constitutional.
Yes.
Who are the good men?
Those who disagree with what the current proceedings.
So what do you call it? What Mr. Dami and his client want necessarily become a national conscience. Look, I don't think Mr. Dami and his client can make their wishes a law on the world. Who are the good men? So they are good in pursuing what in every respect is an unconstitutional act. And the president, who is following the Constitution strictly by its letter and spirit, is a bad man. What kind of reasoning is that? I think that it is the right of everyone, including the CJ, to pursue justice according to the law. After all, in her own words, the law is the law. So she cannot be precluded from accessing justice in the court. However, how she pursues it, the length at which she goes, will determine what is being described as the optics. Clearly, things are not looking too good, and I don't think the DG is whipping up public sentiment favorably towards her. She may have some justifiable reasons, but she may ultimately lose that public sympathy, in my view. Especially the legal team that she has put together. Things are not looking too good.
Thank you very much for speaking to us.
So now you are welcome.
That's why David Ametefe joining us on the line outside Accra to have a conversation on the matter of the Chief Justice and the suit she has filed